Welcome to Legal Opinions with Clementina. I am Clementina E. Ukiri, the Dominus Litis, and today we are dissecting the Legal Practitioners Bill 2025. Is the new 2-year mandatory pupillage a masterclass in mentorship or a sentence to modern-day legal poverty? Share your thoughts. For decades, a new wig could walk out of the Supreme Court, rent a small office, and hang a shingle. That if this bill becomes law, that era is over. You will be required, by law, to serve under a principal for 24 months before you can even think of standing alone. And here is the question: are we protecting the public from half-baked lawyers, or are we just providing senior firms with a fresh supply of cheap labor? Let's get into the legal opinions. Section 25 of the bill is where the hammer falls. It mandates a 2-year internship. Now, as Dominus Litis, I have always advocated for excellence. We've seen it, young lawyers who don't know how to move a simple motion or draft a proper application. The proponents of this bill say we are following the UK or South African model. They argue that the sanctity of the bar requires a period of gestation. You cannot be a master of the suit if you haven't sat at the feet of a master. Conceptually, it sounds like a dream. We want polished, ethical, and practice-ready advocates. But law is not practiced in a vacuum. It is practiced in an economy. Now, let's talk about the meat that most seniors don't want to hear. If you took 2 years of a person's life, you must pay for it. In a country where some juniors are still being paid transport fare as salary, how do we justify a mandatory 2-year lock-in? And for those who think they can bypass this, the bill empowers the restructured Legal Practitioners Disciplinary Committee and new Ethics and Enforcement Committee. They aren't just giving slaps on the wrist anymore. We are looking at the power to strike names off the roll for unauthorized independent practice. The stick is heavy, but where is the carrot for the young lawyer? My verdict? Experience cannot be fast-tracked, but it must be funded. We cannot use the law to legislatively trap young adults in poverty under the guise of mentorship. If the body of benchers and the MBA want better lawyers, they must ensure these lawyers can afford to stay in profession long enough to learn. If you mandate the time, you must mandate the maintenance. Otherwise, we are simply telling the children of the poor that the bar is no longer for them. I want to hear from you. To the seniors, are you ready to pay a living wage to those pupils? To the new wigs and students, does this 2-year wait terrify or inspire you? Drop your comments below. I read every single one. Don't forget to subscribe to Legal Opinions with Clementina on YouTube and follow me on Tina Rahamin Pearls on Facebook. I am Clementina A. Ukiri, the Dominus Litis. The law is settled, but our opinions are just beginning. See you in the next one.